I was a child who was told often that I wasn't dressed the right way or acting the right way and doing what I was supposed to be doing with my body. And so this work is very personal to me. That's the fuel that keeps me going when I am burned out and tired from traveling all over and seeing patients that are also, quite frankly, burned out and tired because of the amount of hoops they've had to jump through. There were 210 prosecutions for pregnancy-related complications in our country. A third of those happened in Oklahoma. So we are in a region of the country where the risk is quite high. Politicians will always say, we're never trying to prosecute pregnant people. And that's quite frankly not true.
Missourians for years before the Dobbs decision were already going to Kansas and Illinois. Even those here in Kansas City or in St. Louis who may have had just a quick jaunt across the river are being displaced because there are patients coming from around the country. We saw in Missouri the first state to deny a pregnant person carrying a dead fetus inside her care at multiple emergency rooms because those hospitals, those providers were scared. Threatening physicians the way that this ban does means that new providers, medical students, and residents don't want to come to Missouri, especially in Missouri, a state with one of the highest rates of maternal mortality and morbidity in the nation. That will have a long-term impact on our state. The opportunity to vote yes on Amendment 3 means that we can rebuild a level of abortion access that our state has never had before. It defers to physicians' judgment to determine fetal viability, and it allows patients to be able to have open and honest conversations with their providers.
All Missourians are on the same team that we want good health care for mothers and we want to preserve life. We have significant concerns about the initiative allowing late-term abortions up until the moment of birth. It would allow young minors to obtain abortions without parental notification and consent. And that provider immunity clause should be a very significant concern for Missourians. And we're encouraging all Missourians to vote no on this initiative.
Our opposition will say anything to distract from the crisis that their abortion ban has caused, and it is a public health crisis.
I think there was some term about post-delivery abortions. I mean, these are not situations that happen. They're not real health care. The nice thing is that the courts have dealt with that head on. The Court of Appeals got to shoot down particular things and say these are not reasonable outcomes. So we wanted to have language that people understood, restore access as much as possible, and then also make that access meaningful. When we had Roe in effect here, it was not a substantive right. We didn't have access. We had trap laws that were shutting down clinics. And so we knew that we needed something that was stronger than Roe, and that is what Amendment 3 will be. But we also wanted to meet Missourians where they were and understand, what language will allow providers to do the work they need to do to ensure life-saving care is available, but also what words in the language make sense to Missouri voters.
These proposed abortion initiatives fail to provide a genuine solution to the complex issue of reproductive justice.
You will actually be embedding a ban into the state's constitution because of the viability language. Those folks who need care and they fall outside of these weeks, they won't get it. In our Constitution, we will criminalize them. We will criminalize the people who provide the care for them. This is not good.
Before Roe was decided by the Supreme Court, advocates were asking for abortion rights, period. Justice Harry Blackmun created this concept of a viability limit to figure out a way to strike a compromise between abortion rights and allowing the government to have some sort of interest in pregnancy decision-making. Viability is vague and it can be defined. And if you don't hold the power in the state, you have to think about who has the power to define when a fetus is viable. This leads to stories like Brittany Watts in Ohio, who was investigated for her miscarriage, and the judge cited Ohio's viability limit as a justification to refer her case to the grand jury. We're also talking about criminalization of pregnant people, investigations of pregnant people who are navigating pregnancy outcomes like miscarriage, stillbirth. And whenever we're introducing police into the framework, we are now talking about a heightened targeting of women of color.
We cannot follow this reproductive rights model because we cannot trust the courts to do what's necessary for us. We're really just opening ourselves up to a whole bunch of harm that we really don't have to do. We can wait, we can get the language right, and we can go for it again next year. We're told over and over again, we can't wait, we can't wait, we can't wait. We can wait for this one. It's important to get this one right.
We have been conditioned to meet the Roe standard. Now we're in a different time. There was a pretty groundbreaking piece of research conducted by Perry Undum where they tested the Michigan abortion ballot and they tested that with the viability limit against a clean version. And the clean version did double digits better. They did not trust that the government would enforce that with any sort of goodwill. And they expressed a complete rejection of government interference at all at any point. But the movement hasn't quite caught up to that. We have an opportunity to rewrite these policies so that we're centering the most marginalized people. And so the invitation to all advocates across the country is really to think about whether we need to negotiate against ourselves at the gate.
I think it's fair for Missourians to be anxious about that. The nice thing is that we've been battling this in 5 different phases just to get on the ballot. And again, the courts have seen this amendment language and the process for what it is. We also wrote this language in a way that the legislature has to meet national, clinically accepted standards from groups like the Society for Family Planning. They set the professional expectations and definitions for these care, and we are not going into this conversation with the legislature in a naive way. We're going to be ready for that.
There's always a disconnect between the law and medicine, which is why the viability piece is tricky. I know that there are a lot of people that have different opinions about it. Think about all the people that it would restore access to. And I would also encourage those people to think about the fact that they are often providing care in places that already have fetal viability standards. Abortion affects all of us. If you don't know somebody that has been affected by abortion, first of all, you probably do. And second of all, you will. We should try to give people their rights back, and we can continue to work around the rest for now.